Imagine an invisible gatekeeper, making decisions that shape your life. It evaluates your loan application, decides your eligibility for a job, even influences your medical diagnosis. But you can't question its logic, you can't challenge its fairness, and you certainly can't understand its inner workings. What if this powerful intelligence, woven into the fabric of our daily existence, operates without oversight, without a clear set of rules? Until recently, for many advanced AI systems, that was the unsettling reality. A frontier expanding at breakneck speed, largely ungoverned. The rapid rise of artificial intelligence, while promising monumental leaps in medicine, efficiency, and discovery, also brought unforeseen challenges. We saw algorithms learning from flawed data, perpetuating and even amplifying existing societal biases. AI systems began making critical decisions in sensitive areas, from predicting who might reoffend, to assessing credit scores, to sifting through job applicants. These were not theoretical concerns. Real people faced real consequences. Lives were impacted, often without recourse, creating a growing sense of vulnerability and a clear demand for accountability. It was, in many ways, a digital Wild West, where innovation outpaced ethics and regulation. But that unregulated landscape was never destined to last. Just as Europe led the world in establishing robust data privacy with the GDPR, it again stepped forward to draw a line in the sand. Recognizing the profound societal implications of AI, the European Union embarked on an ambitious journey to create the world's first comprehensive legal framework for artificial intelligence. The vision was clear. AI should serve humanity, not the other way around. It aimed to foster trust in technology, protect fundamental rights, and ensure that AI systems are safe, transparent, and non-discriminatory. This wasn't just about controlling technology. It was about upholding democratic values in the digital age. So, how does Europe plan to build this digital shield? The core of the AI Act lies in one elegant, yet powerful, concept: risk categorization. Think of it like a building code. You wouldn't apply the same safety rules to a garden shed as you would to a skyscraper, right? A garden shed needs minimal checks. A house has more requirements for structural integrity and electrical safety. A commercial high-rise, however, demands rigorous architectural review, extensive material testing, constant safety inspections, and clear emergency protocols. The stakes are simply higher. The AI Act applies this same logic to AI systems. It doesn't treat all AI equally. Instead, it classifies AI applications based on their potential to harm individuals or society. The higher the risk, the stricter the rules. This is where most people get it wrong. They assume the Act is a blanket ban on innovation. In reality, it's a targeted approach designed to protect where it matters most, while allowing innovation to flourish in lower-risk areas. At the very top of this risk ladder are the systems deemed unacceptable risk. These are AI practices that fundamentally threaten human rights and democratic values, and are therefore strictly prohibited. Think of real-time, remote biometric identification in publicly accessible spaces for law enforcement, or social scoring systems used by governments to evaluate trustworthiness. These are simply not allowed. Then, we descend to high-risk AI. This category is the Act's primary focus and where the most significant safeguards apply. These are systems used in critical areas like managing crucial infrastructure, assessing access to education or employment, evaluating creditworthiness, providing emergency services, or assisting in judicial processes. If an AI system has the potential to significantly impact someone's life, health, or fundamental rights, it falls into this category. For developers and deployers, this means rigorous obligations, extensive risk management systems, human oversight, high-quality data, detailed documentation, and robust cybersecurity measures. Below high risk, we find limited risk AI systems. These don't pose the same existential threats, but still warrant a degree of transparency. The most prominent example here is AI systems that interact with humans, like chatbots, or those that generate deepfakes. The rule is simple. Users must be clearly informed they are interacting with an AI or viewing AI-generated content. No more hidden algorithms mimicking human interaction without disclosure. Then, there's the vast minimal risk category. This includes the majority of AI applications we encounter daily. things like spam filters, recommendation engines, or simple AI-powered games. For these, the Act imposes very few direct obligations, instead encouraging voluntary codes of conduct. And here's a crucial insight. The Act isn't just about restrictions. To foster responsible innovation, it introduces AI regulatory sandboxes. These safe environments allow businesses and researchers to test cutting-edge AI systems under expert supervision, iterating and learning before widespread deployment, ensuring compliance from the ground up, not as an afterthought. This delicate balance between protection and progress is a core trade-off that often gets overlooked. So who ensures these rules are followed? The enforcement of the AI Act is a multi-layered effort. At the European level, a new AI office has been established to oversee implementation, promote best practices, and coordinate across member states. But the real teeth of the Act come from national supervisory authorities, who will monitor compliance within their own countries. And the penalties for non-compliance are severe. For the most egregious breaches, companies could face fines up to 35 million euros or 7% of their annual global turnover, whichever is higher. These aren't just slaps on the wrist, they are substantial deterrents. More importantly, the Act empowers you, the citizen. If you believe an AI system has infringed upon your rights, you have the right to complain to national authorities and seek explanations or even redress. This fundamental right transforms you from a passive user into an active participant in shaping the ethical deployment of AI. Europe's AI Act isn't just a regional regulation, it's a global precedent. This Brussels effect means that any company wanting to operate or sell AI systems within the EU market will need to comply, inevitably influencing global product design and ethical standards far beyond its borders. Other nations, from the United States to Canada to India, are closely watching and drawing inspiration for their own regulatory efforts. But this journey isn't without its trade-offs. Some argue that strict regulation could stifle innovation, while others contend it merely channels it towards more ethical and sustainable pathways. The Act itself is not a static document. It's designed to adapt as AI technology evolves. As AI becomes even more sophisticated, we, as global citizens, face a profound question. How do we harness its immense power while safeguarding our fundamental rights and democratic values? The EU AI Act offers a compelling answer, a digital shield designed not to halt progress, but to guide it responsibly into our collective future.